Hello, everyone. My name is Emily Tyson-Shu. I'm one of the associate attorney with the Estate Planning and Probate Group. And today we're going to talk a little bit about is probate necessary or the circumstances when probate is not required. So before we go in depth into the circumstances where the probate is not required, we can talk a little bit about what probate is. If you want even more detailed information, you are encouraged to rewatch the webinar that was done by the other attorney, Joshua Curtis, sometime last year. And that webinar discussed extensively about what a probate is, which might be helpful to you. But generally speaking, in short, probate is a legal process to essentially settle a deceased person's estate. When a person passes away, the person may leave assets behind, and there are certain claims that we need to deal with, or maybe there are tax filings that we need to take care of. But eventually, the ultimate goal of a probate is to distribute assets to the intended heirs and or beneficiaries. Uh, but under certain situations, a probate may not be needed. And let's talk about what those exceptions are today. So for one, small estate affidavit, usually in a situation where the estate is worth $100,000 or less, and there's no real property involved in the estate, then it's possible that probate may not be necessary for that situation. So if you encounter a situation where the person passed away owning only the liquid assets and the total value of all the liquid assets is below or is worth $100,000 or below, then chances are you may work directly with the financial institutions or banks and using a small estate affidavit to transfer assets. Another situation where a probate might not be necessary is transfer of property via beneficiary designations. If you have retirement accounts or life insurance, you're probably familiar with beneficiary designations because when you set up an account or when you purchase a life insurance policy, you probably have already filled out the beneficiary designations already. And for those assets and for sometimes for other bank accounts or brokerage accounts, you can also go ahead and work with the financial institutions to set up the beneficiary designations. And upon death, the account holder's death, usually those financial institutions can work directly with the beneficiaries on transferring assets without going through probate. Another situation where a probate may not be necessary is that the person is one of the joint owners, and then the assets designated under joint tenancy with right of survivorship. And you might have heard of that already. Joint tenancy with the right of survivorships. You can see this type of designation maybe for a joint account, bank account, or on a piece of real property. Essentially, that you can co-own this bank account with another person under this joint tenancy with right of a survivorship, or you can co-own a real property with another person under joint tenancy with right of survivorship. Essentially, with this type of designation, it just means that in the event of one owner's death, then this entire asset will be automatically transferred to the surviving owners without going through probate. Similarly, on the similar idea, but not the same at all, there's another designation called transfer on death. It could be a transfer on death deed, or it could be a transfer on death designation. So if you have a real property and then you would like to, sorry, Kieran, can I redo this? I feel like I didn't do it correctly.
Yes, of course, no problem at all.
I feel like certain information wasn't accurate, so I want to redo this a little.
Yep, that is totally fine. You just let me, when you go back to the start, it's gonna continue, just continue talking or whenever you're ready to start because it's been
Ah,
recording. Sorry,
okay.
that did not make sense, but I think you got what I meant.
Oh, I only have this one slide, so it's not gonna be long.
Oh, well, you have to start over the entire presentation.
I have one.
You have to start over the entire presentation.
So, yeah. So
Yeah.
in case you're bored, I only have one slide. So it's not gonna, you
Oh,
can see in there four. One, two, three, four.
I saw that. Yeah, so there before I said there's only two slides now.
Yeah, I
Uh,
think I
first one?
only have, yeah, first one and then third, a little bit of the information like here. And then that's it.
Oh, easy. Oh,
I
cool.
meant for it to be around 5 minutes or so. So you don't
Perfect.
have to sit through here with me.
No, it's okay. I love sitting through the webinars. I had
Oh,
Todd's last week
yeah.
and
How long did he take?
he did the Rubik's Cube, but because he already recorded the video himself, it was 35
Oh,
minutes, so I had to sit through twice
what?
because I had to record the
Wow.
recording and then play the recording. So so,
Okay.
I actually like listening and watching. I get like the
Yeah.
pre-presentation
Yeah.
view. So no problem at all.
Got
Okay,
it.
I'm gonna go
Got
back
it.
on mute to start whenever you want.
Ah, thank you. Thank you. Hello, everyone. I'm Emily Tyson-Shu, one of the associate attorneys at Beresford Booth with the Estate Planning and Probate Group. Today, I'm going to talk about is probate. Talk a little bit about probate in this webinar. So we're gonna, talk about a little bit about is probate necessary, and maybe discuss some circumstances when probate is not required. Okay. So before we go into the circumstances where the probates may not be required, we can talk a little bit about what probate is. If you watched a webinar from our office sometime last year, you probably remember that the other attorney, Joshua Curtis, did a extensive uh, uh, conversation about probate. And if you're interested, you're encouraged to go back to rewatch that video because it provides extensive useful information. So, but in short, essentially, a probate is a legal process of settling a deceased person's estate. So when person passes away, the person may leave some assets behind. And eventually we need to sort out where those assets should go. And the person may have some claim, the deceased person may leave some valid claims that we need to deal with, or maybe there are some tax filings that we need to take care of. So essentially, the probate is the default legal process to settle and administer these deceased person's estate. Uh, Probate in the state of Washington is honestly fairly straightforward, not costly at all compared with all the other states. But still, if you're interested in uh, distributing your assets outside of probate, here are some of the options that you may consider. So first, small estate affidavit. In the event that if a person, deceased person, the total assets owned by this deceased person is worth $100,000 or less, and this deceased person didn't own any real property, then probate may not be necessary. Because in that situation, the heirs of this deceased person can generally use a so-called small estate affidavit and to coordinate with the financial institutions or the banks to facilitate the transfer of the liquid assets. In another situation, sometimes some assets can be transferred without going through probate, is when the assets are designated with beneficiaries. So for example, if you have retirement accounts or life insurance policies, you probably have done it already. that you filled out the beneficiary designation. You sometimes can also fill out the complete the beneficiary designations with certain banks and financial institutions on regular checking or savings accounts or your brokerage accounts. Generally speaking, if those accounts or your life insurance policies are designated with beneficiaries, the financial institutions, the banks, or the insurance companies can work directly with the beneficiaries on the transfer of assets without going through probate. Another situation where probate may not be needed, while another situation where probate is not necessary is that when you have joint tenancy with right of survivorship with another person or other people. You may see this designation for certain bank accounts or for certain real property. Meaning that if you co-own a bank account with someone else, or if you co-own a real property with someone else, and you designate this account under the joint tenancy with right of survivorship, or you designate the real property under the joint tenancy with right of survivorship, it means that when one of the owners passes away, then the entire property asset will be automatically transferred to the other surviving owner or owners. In another situation, if you that where the transfer on death deed or transfer on death destination can also avoid probate. So for example, if you own a real property and you would like to pass this real property on to the beneficiaries outside of probate, then you may consider executing a transfer on death deed, specifying who your beneficiaries are. Then upon the death, this piece of real property will be automatically transferred to the interest in this real property will be vested in the beneficiaries. There are certain procedures that the beneficiaries need to take, but this process of probate is not needed for the asset transfer. Transfer on death, you can also see such designation on certain bank accounts as well, or sometimes you will see which is called payable on death. Same thing. You can work with the financial institutions or banks and letting them know that you would like to designate such accounts under the transfer on death or payable on death designation and name your beneficiaries. Then upon death, usually the banks or the financial institutions can work directly with the beneficiaries on the transfer of assets. Lastly, one of the common tools that people would use is called revocable living trusts. For example, for people owning assets out of the state of Washington, and for people who would like to avoid probate in another state, then you can consider using a revocable living trust. Because essentially the idea is that when you create a revocable living trust, sometimes I would describe it as an artificial basket. Then if you put the assets into this revocable living trust, so you put the assets into this artificial basket, then the assets held by this trust, meaning the assets in this artificial basket, will then be distributed to the beneficiaries based on the trust document without going through probate. So that's also one possible option to avoid probate if that's your goal. So now that we know a couple of options or certain circumstances that a probate is not necessary, maybe there are certain considerations for you to take into account. Should I avoid probate? It's a question I think that you can discuss with your attorney during the planning. Usually attorneys should be able to analyze all factors with you, including, pros and cons, whether probate is necessary or whether it's beneficial for you to avoid probate. And two, do I own out-of-state property? If you own out-of-state property, especially if you own out-of-state real property, then chances are you will be subject to another probate at a second stage. And depending on how complicated and how costly the probate it is in a different state, maybe that will factor into your consideration. Because if you want to avoid different another probate in a different state, then maybe you want to do something about it. Oftentimes in that situation, a revocable living trust is a fairly useful tool for people to use. And three, maybe you would like to consider whether you would like to preserve or, stay anonymous with your names. Because probate, like I mentioned at the very beginning, is a legal process. So there are certain documents and pleadings that need to be submitted to the court. And usually for documents submitted to the court, they become public records. And for some people, they don't like such an idea for information to become public. So if that's one of your considerations, maybe that would be a good topic to discuss with your attorney when you're doing your own estate planning, etc. So today, this is all the information that I would like to share. As I mentioned, as a recap, probate is essentially a legal default process when, to settle a deceased person's estate. But during the lifetime, people can do certain plannings to avoid probate, or maybe you are the heir beneficiary or the personal representative of a deceased person, and you would like to figure out whether this estate needs to go through probate. And I hope that I share those preliminary information for you to take into account. If you would like to discuss more, either estate planning or probate, you're welcome to reach out to our office. And I hope today's presentation is helpful to you. And thank you.